All right, welcome. We need to get ready for the jury, and we need to address a motion that was filed at the very, very beginning of the trial, entitled Motion to Prohibit the Imposition of the Death Penalty upon Conviction of First-Degree Murder. This is a case of State of Florida versus Luis, Toledo, 2013, 102-888. We've had arguments on the motion, and I deferred ruling on the motion until it became relevant. It has become relevant given that the jury has found the defendant guilty of first-degree murder as to count 1 and count 2 of the indictment. I am going to deny the motion and file a written order that will address my ruling on the motion, okay? So. Yeah. I do need to ask the state one thing before you even begin. I noticed on the list of aggravators, or one of the aggravators listed, the last one, is the that the defendant had ties to a gang member. Are you abandoning that, or you are abandoning that?
Yes, sir.
Okay, so.
Judge, the defense understands that one of the state witnesses that's going to be presented is a gentleman named Eric. It's Praolini, as a witness to get an aggravator, prior violent felony. And I'm moving in limine to one aspect of his testimony. Well, actually, I do want to make this comment. Number one, the state is under a responsibility to not make this into another mini trial and have to, present every detail of this case. But there is one detail I do want to make sure doesn't come out in front of the jury, and it's this, that Mr. Praolini, when he gave his interview to law enforcement shortly after the events, this goes back to 1999, he said that, Judge, I know you don't know anything about this, I'll give you a thumbnail sketch.
I read the packet that was submitted yesterday, so there are no, there's a couple of depositions in there, I think, and I mean, I vaguely read some of it, yeah.
Basically, 3 people go into a home,
right,
commit a robbery, but
they get caught in the car ways down the road.
Right.
One of the co-defendants has the stolen property in his pockets.
Right, and what they say, what this gentleman told the police back then is when this event occurred, the people that did that to him said, quote, "This is how real niggers do it." And
I'm sorry?
This is how real niggers do it, and I want to move in limine to not have that statement put in front of the jury. It's not relevant to the aggravator in any way, Judge.
Okay. State, any objection to the motion? Or?
We've already discussed it with him, asked not to put it in
Okay. All right, good deal. The motion is granted. All right. Is there anything else we need to address before we bring the jury down?
No, sir. We're working on the trial version of this.
Okay. All right. Okay, I've been informed one of the jurors' daughter has pink eye and she's trying to make an appointment with her doctor right now. So we might start just a couple of minutes late and give her an opportunity to take care of that.
Would you mind if I step out for a moment?
No, we'll be in recess until about 9:05, okay?
Court come to order.
Thank you. I do want to remind everyone to turn your phones off, please. We're ready for the jury. Yes, sir. Go ahead.
Judge, I just want to put on the record an objection to the so-called testimony about the prior violent felony and the defense of this evidence to both at the time. He was back in 1999. He played the case Pence versus State, 794, Southern Second, 1249, Article 3 Court from 2001. Basically, Judge, what it says is that remotest time can be argued as far as how much weight it's given, but the defense wants to take it one step further and have you rule that still below 15% is all.
But if I recall correctly, the sentence was an 8-year sentence, which my math does come out all right. That means he came out sometime.
About 5 years before the crime.
So, yeah, I'll overrule the objection. All right. Is the jury in the back? Jury back here? Mr. Nielsen, did you get to see the video? You have not seen it?
I just gave it to them this morning as well.
Okay.
Only recently.
You say you're not intending to use it until when?
Later today, the victim impact evidence in that area.
Okay. Will it be after lunch? I just don't want to have the jurors sitting around while we...
No, I think it'll probably be after 11:30 for sure, so,
Okay.
yeah. Just for your purposes, we have 2 witnesses, the prior victim this morning, and a fingerprint technician. And then after that, we intend to do the victim impact. We'll probably need to talk about if the final video of some of these others are going to be read.
Okay.
The video will be allowed, and if it's in there.
Okay. Ready for the jury? Bring the jury. Thank you. You may be seated. State, you may call your first witness.
State calls Eric Craolini.
Yes, ma'am.
Okay, you may have a seat right there. Sir, make sure you speak loud and clear and close to the microphone so the viewers can hear what you have to say, okay?
Yes, sir.
You may proceed.
Thank you, Your Honor. Sir, could you introduce yourself to us, please, and spell your last name?
I am Zarek Emilio Praolini, Praolini.
And how old are you, sir?
43.
Back in December of 1999, did you live in the area of Davie, Florida?
Yes, sir.
And did you have an encounter with the defendant on or about that month?
Yes.
Okay. Please explain to us where you were living and the circumstances of your life, just kind of in a general way.
I was living in Southwest 41st Street in Davie, and in a two-story apartment building. Really not much. I was living and working right by. And what else did you want to know? I'm sorry.
Were you married at the time?
No.
Were you dating at the time?
Might have been dating, but single for the most part.
Okay.
At that time.
On December 5th of 1999, were you at home that evening?
Yes.
And around the time of about 1:30 in the morning, did you have an encounter with the defendant?
Yes.
Explain that encounter to us, please.
I received a knock at the door. Someone who wasn't wearing a mask was asking me if a girl had been living there. I said no. I had a girl on the couch already, so I didn't know who they were talking about.
Not the same person, not the same girl.
No. They were asking for a Damaris, and the girl that was in my couch, her name was Karen. She's a friend of mine.
Okay.
And then as soon as, like I said no, I noticed someone to my left, to the left of the door. They started coming in. Then I noticed someone running around from this side. They tried coming in. We fought. Gun was pulled to my head. Sorry.
How many individuals
3
total?
3 individuals.
How were they dressed?
In hoodies and jeans.
Okay, and you said something about a mask.
Well, they had their hoodies like closed up to where they couldn't see the mask, or at least the 2 guys did. The guy at the door, he had his face wide open.
Okay, but the 2 others had something covering them.
Yes, the hoodies pulled all the way down.
Now, they entered your home.
Yes.
Tell us how that occurred and what occurred immediately thereafter.
We started fighting at the door. Gun was put to my head. That's when I stopped fighting. Went straight to the ground. They put my face in the corner of the couch in the ground so that I couldn't see anything. Was head kicked. Gun was put to my head, back of my leg. A bunch of threats were made.
Threats of what?
My life, taking my life. They wanted to blow I remember them saying that they wanted to blow the back of my leg off so I could just bleed there. And someone said to throw a pillow over the gun to make it a silencer so nobody would hear it. None of that happened, thank goodness, but they did put the gun to my body a couple of times, freaked me out. And they continued to ransack my place and left it was very brief.
How long did it last?
Not more than 15 minutes.
Okay. What happened to the girl on your couch?
I believe, I couldn't see, but from what she told me, she was tied up and they put a blanket over her, but they didn't harm her or anything like that.
Did they take her outside your range of view?
No, she just, I was on the couch on the floor and she was on the couch, like right next to me, but I'm face down like this and I can only see out of the corner of my eye that way.
You said a couple times you were on the couch and the floor.
On the floor of, like where the couch and the floor meet, they had my nose, so where I was looking in that direction, so I couldn't see.
So your face was actually pointed underneath the couch?
Yes.
Okay. You were laying on the floor.
I want to say the right side of my face was on the ground and my nose was between the couch and the floor.
You said that Karen was tied.
Yes.
Were you also tied in some fashion?
Yes, they took a cell phone charger wire and wrapped it around my hand a couple times to keep me bound. And
were your hands tied in front of you or behind you?
No, in the back. I was on the ground.
From your vantage point on the floor, what were you able to perceive them doing?
I could hear them going through my place, just ransacking, stuff falling, stuff crashing. Just stuff being knocked over.
You said the encounter lasted about 15 minutes. How did it end?
It ended on the way out. I heard them, let's go, let's go, let's go. And then one of them at the door, they point, I could see from that point, I could see the door because I had turned my head the other way and I could see from the corner a gun being pointed at me and said that this is how real men do it, but they didn't use that term. They used a much more vulgar term, which I don't think I could say here.
Okay. Do we really need to? I'll sustain the objection if there's going to be an objection. Okay.
How did these 3 men leave your apartment, Mr. Preolini?
Out the front door, 2 left. I believe it was 2 left because the one that was walking out the door had said that statement. And then I heard his footsteps go away and a car start. Right then I ripped off the whatever was binding me, the charger wire, closed the door, went to an empty room that I had a cordless phone on and called 911, looked out the window and seen what they were driving, gave them the description, or gave the police the description of the car that I seen. And they caught them shortly after.
Were you able to go to the location of their arrest?
Yes, where they had pulled them over at.
And were you able to identify or at least see the three individuals responsible for the crime?
There were 3 individuals there. The one gentleman that knocked on the door, I seen him, but I couldn't see, the faces of the other guys because they were covered. Not at the time of at the gas station.
When you got to the gas station, were you able to perceive them clearly? Could you see their faces
Yes.
now?
Yeah, they had nothing on.
Do you recall those faces?
Not so. I mean, now, yes, but
I'm going to approach with what's been marked Safety Exhibit Bravo for identification purposes. Without telling us what this is, you recognize that particular document or photograph.
yes,
And is that one of the individuals that was involved in this crime?
yes,
The photograph was taken at or about the time of the crime itself?
yeah, because he looked just like that.
Judge, there are no objections to this one. Bravo.
Okay, any objection? All right, the item will be admitted into evidence. You may proceed.
Thank you, Your Honor. So the photograph that you've just identified, that's one of the individuals that was involved in this
Yes,
crime?
sir.
Okay. Of the 3 individuals that you saw at the gas station, did you know any of them?
No,
You'd never seen them before?
no.
This particular individual, though, did you have an opportunity to see him at the gas station?
Yes.
And what was he doing when you saw him?
He was sitting in the back of the police car.
And what was the lighting at that time?
There was like the dome light from the police car, and he was in the back seat, and all I seen was just him looking at me in a very mean way.
And did you have any conversation with him at that
No.
point? Now, I recognize that 3 individuals were stopped by the police and you arrived to that location. How are you sure that those 3 individuals are the same individuals that robbed you?
They had my property that was stolen from my apartment.
What particular property did they have?
They had a beeper of mine, which I paged and immediately went off inside the car. Couple of rings, silver rings that I had, and a very unique necklace that I had.
All of those items were either in the vehicle or on their person at the time?
Yes, from what I understand.
Now, I'd like to turn your attention back to your apartment. After you had the opportunity to get up and move around, what did you find as far as the damage in the apartment?
They pulled forward a desk of mine, knocking my laptop. Laptop was broken because it was in an open position and fell. Gone through all my drawers, just stuff all over the floor. There was an urn with my friend, a dear friend of mine's mother's ashes in them. That was smashed on the ground. And my mother's ashes were in a box, and that was opened and gone through as well.
Did you later learn why that box had been opened and gone through?
Yes, sir. The detective.
Judge, hearsay is admissible at this point.
Overrule.
Sir?
The detective had told me that one of them, I forgot which one, had dipped into the box thinking, because my mother's ashes are in a cardboard box in a plastic bag, and somebody thought that it was a bag of some kind of drug that was sniffable, and they attempted to try and sniff it, from what the detective told me. So they sniffed
So
my
someone actually snorted your mother's ashes?
Yes.
Talk with us about what injuries you sustained during this encounter.
I didn't seek medical attention because I was just freaked out and I just wanted to get out of there. I was urinating blood for about a week. Bruises, knots on my head. Physically, psychologically, it's a whole different matter, but...
Did you ever move back and live in that apartment?
No, I stayed away for About 2 weeks, went there with a bunch of friends in a trailer and emptied it out. And that was the last I seen of that place, unless I drive by it randomly, but I get a weird feeling in my stomach whenever I drive by there.
To this day?
Yes.
Judge, I have no further questions. We're after the photograph is published by
You
Hackett.
may. Hand it to the bailiff.
Take one for the record. I do have an additional couple of questions, I'm sorry. Mr. Preolini, after you saw these individuals on that night, was a court case initiated?
I believe so, yes, sir.
And were these individuals prosecuted for their crimes that night?
Yes.
Okay, and without telling us the outcome of those cases, are you aware that there was a prosecution and that something happened?
Yes.
Thank you, sir.
Any cross-examination?
Morning, sir.
Morning.
The things that you described that occurred in the home, you don't know which of these three people were doing these things that the police told you about, right?
No, sir.
And do you know how old Mr. Toledo was in 1999 by any chance?
No. I didn't really stop to ask anybody's age.
All right. And you described the incident with the gun, but you do not know which one of the three people pulled that gun on you. Is that correct?
No, sir.
No?
No, I do not know which one.
And the statements that people were making, you don't know which ones the three were making the statements either, do you?
No, sir.
And the statement specifically about you potentially being shot, you do not know which of the three people in your house that day said that. Is that correct?
That's correct.
And in fact, you indicated that you had ID'd, I believe Mr. Toledo was one of the people involved, but isn't it true, sir, at a later court hearing, you were not able to identify Mr. Toledo as being there?
Well, I couldn't. The only person I can identify was the person who knocked on the door because they did not have a mask on.
Okay.
Or, I'm sorry, a pulley, a sweatshirt pulley.
And so that would mean that if you're IDing this person, then that would be the person who did not have something covering their face. Is that correct?
Repeat the question, I'm sorry.
The person that you could ID, that obviously that person then did not have something covering their face. Is that correct?
Correct.
And sir, is it true that the people that broke into your home that night believed that perhaps you were some type of drug dealer?
By their actions, that's the only thing I can suggest.
You were being asked for ecstasy. Do you recall
Ecstasy and GHB.
that? And you were asked if you had some rolls of money around too, right?
I was asked, yeah, for money and just whatever. Where's the S word?
Okay. All right, Judge, I don't have any other questions. Thank you,
Thank you.
sir.
When they were asking for drugs and money, did you have any of those things in your home?
I had a $100 bill and a small bag of marijuana.
How small?
7 grams.
Like personal use?
Yeah,
Small?
personal use.
But you didn't have any of the stuff that they were clearly looking for? Right?
No, nothing. I didn't have GHB or coke or ecstasy.
And in fact, you had never seen these people in your life?
No.
Now, as far as the three people go, you don't know which one was holding the gun or which one was making threats to you or which one snorted your mother's ashes, do you?
No, sir, I do not know.
But were they all acting together?
I know I had one that was on me, like keeping charge of me or making sure that I stayed and, watching me and my friend Karen. And I'm assuming that there was the other two were going through all different parts of my place.
Did any one of any one of these three individuals back up and say, hey, I don't want any part of this?
Not that I heard of, no.
Fair to say that all three of them acted together?
Yes.
Thank you.
All right, thank you. Any recross? Thank you. May the witness be excused. State?
Yes, sir.
Defense? Thank you, sir. You may step down.
Thank you.
State, call your next witness.
Erica Stammer.
Raise your right hand and be sworn, please.
Yes.
Thank you. You may proceed.
Thank you, Judge. Good morning, ma'am.
Good morning.
Could you introduce yourself, tell us what you do for a living, and spell your name for us?
My name is Erica Stammer, the examiner.
Okay, and give us a thumbnail description of what a latent print examiner does, and keep in mind that Crystal Bustamante has already testified in this trial.
The latent print examiner in my unit, we try and identify latent prints that are found at crime scenes and any other casework that involves fingerprints. We also verify the identity of subjects arrested at the jail, and also we have on occasion to go to the ME's office and identify deceased individuals and anything else related to fingerprints.
Crystal Bustamante is, in fact, a co-worker of yours,
Yes, she is.
and she works in the same department, does the same type of work, right?
She did.
Before her transition
Yes.
out of back to being a regular deputy, but she did it in 2013, is that right?
Yes.
You mentioned a moment ago that you work with booking fingerprints and fingerprints of individuals who have been arrested. Were you called upon with respect to this particular case to obtain the fingerprints of Louis Toledo?
Yes, I was.
Okay, and tell us how that was done, please.
I was given an order to take his fingerprints, so I proceeded to go to the jail and roll the prints in ink myself.
Tell us how that's done when you roll a print in ink.
Basically, there's a fingerprint card and an ink pad. I take the finger, roll it nail to nail in the ink, and then I transfer it onto a fingerprint card,
Just like we see on TV.
just like you see on TV.
And after you get the fingerprint on that card, what do you do with it?
In this particular case, I fill out the name, and on the back, I also sign and date and put my DID on the back. And then it's brought back to the office to where I do what was asked of me.
Okay, and in this particular case, were you asked to compare what's known as a judgment and sentence, which are court papers related to case number 99-21641, a case originating in Broward County, which contains Davie, Florida?
Yes,
Okay, and did you examine the 1999 documents related to the conviction of an individual by the name of Michael Garcia?
yes, I did.
Judge, may I approach with the mark C and D for identification purposes?
I may do so.
And do you recognize State's Exhibit C for identification purposes?
Yes, I did.
And what do you recognize that to be?
This is a copy of the ink-rolled fingerprint card that I took at the jail.
Yeah, I need to speak into the microphone, please.
This is the copy of the fingerprint card that I rolled in ink at the jail.
The fingerprints of Louis Toledo?
Yes, sir.
I'm showing you what the mark State's Exhibit C for identification. Do you recognize that document?
Yes, I do.
And what is that, ma'am?
This is the judgment and sentencing print that was provided to my office by your office.
This is the judgment and sentencing paperwork that relates to Michael Garcia from 1999. Is that correct?
Yes, sir.
Does it bear no objection to the C and D and evidence takes next?
The objection? Okay, based upon previous ruling, the items will be admitted.
Page 3 and page 2 and page 3 is
Ms. Stamer, I'd like to talk with you about State's Exhibit 3, the judgment and sentence paperwork as it relates to the prints of Michael Garcia from 1999. Did you find, or were there attached to that paperwork fingerprints associated with Michael Garcia?
Yes, there was.
Okay, and did you make a comparison as it relates to the fingerprints of Michael Garcia to the fingerprints that you took at the jail of Luis Toledo?
Yes.
And what were your findings with respect to that analysis?
I found that the prints provided in the JNS pack did match the prints that I rolled at the jail,
Meaning what?
that they are the same person.
So Michael Garcia from 1999 is Luis Toledo from 2013.
Yes.
Judge, at this point, I have no further questions for the witness, but would ask to publish Exhibit 3 by passing to the jurors.
Publish the exhibit first. And again, once you retire to deliberate, you will have these exhibits to examine them. Your heart's delight.
Judge, I have no further questions for the witness.
Any cross-examination? All right, thank you. May the witness be excused. State?
Yes, sir.
Defense? Thank you, ma'am. You may step down. Make sure she doesn't have any exhibits with her. Got them all? Okay. State, call your next witness.
Just give a couple of documents that you would have to court take additional notice of.
Very well. For how long? How long? Okay, let's go back to the jury room.
All rise.
All right. Let's address the issues we need to address.
Yes, sir. I provided this morning, we received this morning final version of the letters intended to be read by the victim's family. Provided those to Mr. Beckler, if you have comments and questions to make with respect to the language.
Can I see what we're going to... Okay, and these are victim impact statements?
Yes, sir. The victim impact statement of Perez, Michael Otto, and myself.
Okay, and I'm assuming that each of them will be reading their own?
Yes, sir.
All right, and is there an objection to all three of them, or a specific one, or?
I don't know, sir. I think there's language, specific language within the letters.
Okay, where do you want me to read?
I guess go one at a time.
I don't, none of these are signed, so I don't. Okay.
Does the defense doesn't have an objection to what she's got here to read? I don't know if it's one word or
Which one?
not.
Grandmother in Spanish. Is that what you're asking?
I don't have any objections to her other than
This for the record, abuela is spelled A-B-U-E-L-A.
record reflected by engaging in conversation with the court, not withdrawing a pre-trial motion.
evidence could not be presented to the jury because it's not an aggravating factor. There's no fair use of the
Okay. I think she's, previous court's previous ruling will stand. I think when she testified, I've heard this word in the testimony. I can't remember when it came in, but, right, okay, all right.
All right, so this is a particular order, there's one from self-children, biological father, Mr. Otto.
Okay, all right.
Judge, there are a number of sentences in here, and the defense wants to have exactly or instructed on the jury. I think the only way I can do it is one at a time.
Yeah, that's,
All right, so, second paragraph from the top, Judge, the defense objects to the language, the first sentence of the second paragraph, specifically the language says, speak about a very horrific, selfish act of violence, rape that occurred in the early morning hours of October 23rd, 2015. That's exactly the defense comment on these acts.
what's this state? It's supposed to be the quality and nature of the individuals in life, not about,
And I'll defer to the court on all of those.
yeah, if we can just eliminate the words,
Would you mind scratching through your copy and I'll provide that to the
okay? I got one. I just eliminated the words, a very horrific, selfish act of violence and rage. So it reads better, it just reads, this is the first opportunity as the father of these two young, innocent children, Talia and Michael, to speak about what occurred in the early mornings. Okay, next one.
So that's really not correct. It's not supposed to speak about what occurred. It's supposed to speak about how it affected him, loss of children. That's essentially the only language that refers back. These were talking about what occurred.
Okay, well, so far there's nothing prejudicial in the statement that I've read. What's the next sentence?
Next paragraph down, third one is better. The beginning of the third line down says, not knowing the evil that has occurred hours ago, suggested that happened not
Is there more in that same paragraph? Well, tell me all of it in that paragraph.
So the sentence, third down, beginning of the third sentence, not knowing the evils that occurred hours ago. I don't have a problem with that. Remember my phone ringing until we got more than some closer. Okay, then it says, when I played the message back, he said I didn't think much of it at the time. When I played the message back, he was trying hysterically. The words weren't clear and comprehensible. I think that's something Mr. Otto would have
No, the objection will be overruled. Next one.
How about the last part of that paragraph? He says, hearsay, that these are things Lewis did something to them. That's what happened.
Okay. I think the jury has found him guilty of having done something to them, so I find that to be harmless at best. I'm going to make one modification on the third line down. It's not knowing what had occurred, and eliminate the words, the evils that. Okay.
Again, reaffirm the court on
All right.
So,
Fourth paragraph.
The third sentence found good, starting in the middle of that sentence. The words on here, what would they look like when I found them? But I still recognize them, as I remember them. I just wanted them to be safe in their home. The defense position is still a position of record. And they doesn't know what's going on. He's taking responsibility of disposing of the body somewhere else. Therefore, he will know how to answer the question to Mr. Otto. We would object to that being put forth as
Okay. I would overrule the objection on that one.
Next paragraph down. Last full sentence. Another lost faith. Children will be forever safe and sound. With our Heavenly Father above, and one day I will see them.
You have an objection to that? Objection will be overruled.
Second page, Mr. Otto, fair statement. Last paragraph, I asked one to read it full.
Last paragraph. Okay. Let me tell you what I'm thinking, and then you tell me what your objection is. The first portion of the paragraph, including the first, second, third, fourth, and fifth, I think should come out. That's more appropriate for the sentencing by the court than for the jury's consideration at this time. From then on through, from the words, but the fact of the matter is that I still do not know where my children are, I think that's all fair, all the way to the end. Is there an objection from there forward?
To the record, Judge, yes, if we wanted to check the following line. At this point, only one is some sort of closure, only one doesn't place to go to talk to my children, let them know how much they are loved and missed. The whole that's sitting out with it, the whole that is left in my heart is close to the burden of blood. It's not good. So, what's subtly going on here, Judge? Thing. What's going on? Burden. He wants the jury hold it against you. Find a way to kill him. Based on the fact that they don't know where his body is. And in reference, one reference to it in the past, but then bring it up again. Basically, try to explain to the jury what this is ultimately going to do. So if he won't tell anyone what the bodies are, when our position all along is he doesn't know what the bodies are. There was some evidence to the contrary, perhaps it could be dealt with. That's our objection.
Say it again.
This type of language, I would suggest to the defense is also another comment on himself. Really,
Okay, the objection will be overruled. I've looked at the statute and case law that addresses this issue, and I believe it's well within the statute. That's the last on, I think that's father's statement. Who is the last statement from? Okay. Is she necessary? Let me just tell you this, that this is always a place where error can manifest itself. I can understand a grandma and dad testifying, but aunt testifying when Ms. Suarez, Yesenia Suarez, is not part of the death penalty portion of this. I'm not sure about that. So I'll read it. I mean, what's your objection?
the entire first paragraph. And I also want to read this,
Let me read it. Okay, anything else? I think I'm going to limit it to the two witnesses, okay?
Yes, sir.
All right. This is a statement of mom and dad and grandma. This is a sister statement. I think they should be marked as exhibits for appellate purposes, so. Okay. We're ready for the jury? Have them bring the jury down. Are you introducing those things into evidence, or they've already in evidence? Okay, you want to do that in front of the jury, or? I looked at the packet that you gave me yesterday. Yeah, I've seen them. Yes, sir. I do. You're speaking about the one that is in the final set? It's the same one. Okay, then I'll read it. You ready? Then bring the jury in. And we're going into victim impact right now, correct?
I'm sorry?
We're going into victim impact right now. Okay. All right.
While the jury is in the presence of the court, excuse me, jury.
Thank you. You may be seated. State.
Judge, the state will move again to put into evidence items F and G. Excuse me, F and E. F is the letter and records from the Office of Executive Clemency of the State of Florida. E is the certified judgment and sentences against Michael Garcia, certified by the clerk of Broward County. As it relates to that case.
Okay, any objection? Okay, the items will be admitted into evidence. Okay,
At this point, the state would intend to move to victim impact.
all right. Ladies and gentlemen, I have an instruction for you. You will now hear evidence about the impact of this murder on the family of Thalia Otto and Michael Otto. This evidence is presented to show the victim's uniqueness as an individual and the resultant loss by Thalia's and Michael Otto's death. However, you may not consider this evidence as an aggravating factor. Your decision must be based on the aggravating factors, the mitigating circumstances, and the weighing process upon which you will be instructed later on. You may proceed.
State would call Felicita Perez.
She needs to be sworn again, I think. Just. You may proceed.
Thank you, Your Honor. Ma'am, could you introduce yourself again, please?
Felicita Perez.
And have you prepared a statement for the jury's consideration and for the consideration of this court today?
Yes, I did.
Would you please read that to us?
As we all know, October 23rd, 2013, changed my life and my life completely. Thinking back, I should have never let Jesse, Thalia, and Elisha leave my house on that terrible night of October 22nd. I miss them so much. I miss watching them play with one another and play with them. I miss going out to the park and riding our bikes. Thalia will no longer call me at work on Sundays to ask at what time I'm getting out of work to pick her up to go bike riding. They were such a happy kids, and it was so much fun to be around them. I miss going to the movies on Grandparents' Day with Thalia and Elisha. We like watching old Disney movies, but the favorite one was Brave. I still stand on the corners of the street, hoping that they will come across the street to visit me. I miss picking them up from school and taking them to my house to feed them their favorite food, pasta with chicken, rice, beans, chicken nuggets, or tostones, those are yellow plantains. I miss singing happy birthday on their birthday and buying them their heart desired. It was always, Abuela, I want this or that for my birthday. I can no longer do this. I will no longer see them on Christmas doing our family tradition. Christmas in pajamas, opening their gift after breakfast. I remember our last Christmas together. They asked me to take them to Dollar Tree because they wanted to surprise each member of the family with gift. The gift they bought with their own money. Thalia bought me a picture frame that I still keep like a treasure. Elisha bought a timer that looked like a soccer ball. He loved that gift. He said, that's for mommy, Semi, and for the family. They will no longer buy gifts to surprise anyone. My grandkids had a tender, loving heart. I can no longer pick them up on Sabbath morning to take them to church early so they don't miss Sabbath school. I'm missing Thalia in her cheerleader practice. She was so happy to be part of that team. She loved to do all kinds of stunts, cheers, split, and she had mastered the cartwheels. I miss you, Talia and Elisha. Life is not the same without you. Titi Daisy, Titi Fini, Titi Nani, Tio Freddy, Tio Jonathan, your cousins, Kelsey, Crystal, Cindy, Suhaili, Ashley, Becky, Anthony, Isaiah, Jocelyn, and all the family misses you so much. You didn't even get to meet your new member of the family, your new cousin, Emmanuel. Sorry, my sweet Aliyah, because I will not be able to see you graduate from high school or college. I know you will always wanted to be a vet. Sorry, my sweet Elisha, because I will not be able to see you graduate from high school or college. I know you will have to make a great computer programmer. I will not have pictures of those milestones in your life. The whole family miss you so much. You are no longer present as 4th of July, Thanksgiving, Christmas gathering, and Easter with friends and family. Life is not the same without you both. There is emptiness with them. I will love you both to eternity.
Thank you, ma'am. I yield the floor to the defense.
Cross-examination. Thank you, Mr. President. You guys step down. State, call your next witness.
State calls Michael Otto.
You raise your hand, be sworn, please. You may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning.
Would you introduce yourself to us, please?
My name is Michael Otto.
And do you have a statement that you prepared both for the court and jury's consideration here today?
Yes.
Could you please read that for us?
Just going to start with a quote. It says, "From the very first breath of our child to the very last breath we take, we watch, we worry, we pray. Our children are our flesh and blood. Their joy is our joy. Their dreams, our dreams. Their pain is our pain, and their death is our death." This is the first opportunity as a father of these two innocent children, Talia and Michael, to speak about what occurred in the early morning hours of October 23rd, 2013, the day that would not only change my life forever, but the many others who knew and loved them as well. On the morning of a Wednesday, October 23rd, 2013, I woke up just like any other day, eyes open, heart beating, breath in my lungs. I started my day with a cup of coffee and prepared myself to work, not knowing what had occurred just hours ago. I remember my phone ringing early that morning, and I saw an incoming call from Felicia. I didn't think much of it at the time and let it go to my voicemail. When I played the message back, Felicia was crying hysterically. Her words were unclear and incomprehensible. Something obviously wasn't right. I called her back. That is when Jasinia's best friend Sabrina answered the phone and gave me the news. Jesse and the kids were missing, and Felicia thought Lewis had done something to them. What will precede are many long months of searching anywhere and everywhere. At this point, I was afraid of what I was looking for. I was essentially looking for my two dead children and their mother. What would they look like if I found them? Would I still recognize them as I remembered them? I just wanted for them to be safe and at home. We searched with family members, volunteers, local police agencies, as well as a group of people from Texas EquiSearch. We were all determined in finding them and bringing them back. We went through swamps, lakes, woods, parks, sewers, and even garbage landfills. I wanted that fatherly instinct to just somehow kick in and let me find where they were. I would cry out their names in hopes of hearing a voice call to me for help. Unfortunately, none of that ever happened. Talia and Elijah were two beautiful, loving souls with huge hearts. They had made many friends and loved ones throughout the 8 and 9 years of their lives. They had met over 200 relatives, and yes, that was just Felicia's side alone. From their school, youth groups, along with kids in their own neighborhood, they made new friends everywhere they went. They attended church and believed in God, and that is the only real comfort for me. Although my faith in God will come in question 4 years previously, I never lost my faith, and I still believe my children were forever safe and sound with our Heavenly Father above, and that one day I would see them again. My daughter Talia Yvette Otto was born on October 8, 2004. She was always my little overachiever. She had a voice like no other. I used to tell her all the time how much she sounded like Minnie Mouse. But you could tell from the start that she was going to be a brilliant mind. She would always pay close attention to her details and worked very hard in school. She wanted to put her best into everything she did. If she started something, she would finish it. There really wasn't anything she did not like to do. Such creative, beautiful mind, just full of love and life, not a hateful bone in her body. Talia loved to draw, paint, read, do puzzles, and even pillow fight sometimes. She had a love for nature and the outdoors. Anytime she had a chance to be outside, she took full advantage of it. A playful and friendly child she was. But more than anything else, Talia loved to ride her bike. Any chance she had, she would ride her bike. She could ride a bike for miles without even getting tired or breaking a sweat. Such an active girl she was. Her abuela, Felicia, just bought her a new bike for her 9th birthday and her very last. She was full of joy when she saw it and couldn't wait to ride it. Towards the end of Talia's short life, she had also recently started getting involved in cheerleading. When I went to watch her at a practice, she was nothing less than spectacular. I knew she could do whatever she put her mind to. My son, Michael Elijah Otto, was born on August 19, 2005, just 10 months apart from his sister. Everyone thought they were twins growing up. He was my first and only son, my mini-me, the one who was supposed to carry on my name one day. When Elijah was younger, he couldn't pronounce Talia's name. He used to call her Lala. That's how Talia got her nickname. Elijah was a handsome young boy. His funny faces and cute smiles could lighten up a room. He was an active and loving son and a devoted brother. Elijah was diagnosed with ADD some while back. He took a little longer to learn and finish things in school, but he would always try his best to keep up with his sister. He liked playing baseball, basketball, and riding his bike outside, but when it came to Elijah's favorite pastime, his passion was to do what most boys love to do, and that was to play video games. He was very good at it. Elijah would try and master every game he played. He would get so good at times, he'd even get lucky and beat me once in a while. I never got a chance to teach my son how to slam dunk a basketball. I never got a chance to see him hit a home run in the final innings of a baseball game, or any of the things a father might anticipate. The fact of the matter is that I still do not know where my children are. We still have not been able to find them in order to lay them to rest. At this point, all I want is some closure, some sort of closure. All I want is a special place to go where I can talk to my children and let them know just how much loved and missed they are. The only way I believe I will ever find peace in this lifetime is to one day be able to find my children and lay them to rest. The hole that is left in my heart because of their murder is much more larger because it does not appear that I will ever be able to do so.
State would yield the floor to the defense.
Any cross-examination? Thank you, sir. You may step down. Ladies and gentlemen, at this point in time, I want to give you a 2-hour lunch because we have some matters to go over with the lawyers. So if you'll be back by 1:30, and I'll give you a chance also to get a decent lunch.
All right.
Okay, the jury's out. We need to address the video before we go to lunch. I'd like to do that now.
Would you like me to play it in here? I know the defense hasn't had the opportunity to review it.
You haven't seen it yet? Okay, then I guess we're going to have to, I'll play it. It's only, I think, a minute long.
Thank you.
I did. Okay. You may. All right. And then I think the video has been proffered. Is there any objection to the video? Okay. Did you have a general objection to it?
No, sir. It's just too prejudice. It's just too prejudice. Case law says that you're allowed to take into consideration harm done. That's the thing. This can't be about the defendant. It can't be about the recommended sentence. It can't be an opinion from the court. It's supposed to be that. According to Jordan versus State, it can't be over-limited. Must be limited to the impact that they could have on the witness. There's no witness. And it's not big impact. Incredibly, this is the crazy prejudice of this ability. This time, you don't find it having proper impact, although it's that's not proper. If the court can allow pictures, that's certainly okay. It's only similar to that. It does not limit the victim. It does not limit the impact. It does impact the witnesses that testify. They're going to see pictures. This video is supposed to be like pictures. And you're going to have to do it. It doesn't fit the definition of victim impact law.
If I may.
Yes, sir.
The state recognizes the limitations and constraints placed upon victim impact testimony and evidence. This would fall under the category of victim impact, or could, but I think it's more appropriately offered under the CCP aggravator. As a video of the victim during the course of her life, it gives the opportunity for the jury to consider the mindset of the defendant in killing someone of this size, of this nature, of this relationship to him. And the state has the burden of proving a heightened premeditation, the cold and calculated nature of this crime in an effort to establish that particular aggravator. I think having the opportunity to see this little girl in color, in life, as the defendant knew her, gives the state the ability not only to prove this aggravator, but to make arguments about his state of mind and what it took as it relates to this little girl. For the purposes of the record, these children were not found. Had their bodies been located at any point, there may be additional aggravators that could be sought by the state. As the defendant's been found guilty of these crimes, there's no doubt that remains as to who's responsible for them. And as the court knows, the CCP aggravator carries great weight when it's reviewed by courts further down the line.
Somehow leak out video of the little girl talking about birth. That's just not the office of the impact. You have to do that. Be an office for something else. Take it out and that's the way Kevin told you. My understanding is not being offered to this man. Yeah.
Okay, I'm going to sustain the objection.
Yes, sir.
Okay. The video will not be played for the jury.
Yes, sir.
All right, you can reserve it and play it at the Spencer hearing if one becomes necessary, or any sentencing hearing. All right, thank you. Is there anything else we need to address before we go to lunch? Okay, be back 1:30.